Right,
Let me see if I understand your claim, because some of the questions and the discussion up to this point is a bit confusing to me. I thought your claim was that there is a violation of the takings clause, and you can therefore bring a suit under 1983 when the state does something that constitutes a taking, but at the same time says, we're not paying you anything for this. Now, it's not a question of when they would have to pay once they've admitted that there's a taking, but when they do something that constitutes a taking and they say, no, this isn't a taking at all, and therefore you're getting zero, which I understand to be your claim here, then you can go directly to federal court and bring an action under 1983. And to require you to go to state court before you do that is essentially to require you to exhaust state remedies before you can bring a 1983 claim, which is never required under 1983. I thought that was your argument.
Right, and that is one of our arguments, is that when the government, the township here in this case, invades property without condemning it, it's clear that it's not compensating, and your claim
accrues. Well, how is it clear that it's not compensating? In other words, what Justice Alito says clarifies matters considerably, that if the state has already said we're not compensating, then it seems you can claim both that you've had a taking and that the state has refused to compensate. But I thought that the question here arose from the fact that the state has not said yet that it's not compensating, that instead it uses the inverse condemnation proceeding to make that determination. Is that wrong?
Yes, in this way. The township is taking her property. The township has imposed an easement on Ms. Knick's property that allows the public in every day of the week, every day of the year. It has the power to condemn easements. It did not use it. So we know that the township is not compensating her. It denies that there's even a taking. So it's not a matter of what the state does. It's a matter of what the township, as the defendant that's taking her property and could have used condemnation and declared a taking, gone into state court, kept it there, but instead used its regulatory powers.
The township has imposed these restrictions on the property, and it hasn't said that it will pay anything for it. Of course, it hasn't said that if you sue us in state court and you win in an inverse condemnation proceeding, which we will resist, we will refuse to pay the judgment of the state court. It hasn't said that. But it certainly has not said, we admit that this is a taking and we owe you money. And you have to go to state court to determine how much money we owe. Am I right on that?
That's right. And the issue is the entitlement. The township denies that there's an entitlement to compensation.
But does it? I mean,
Counsel, I think this gets back to Justice Breyer's question a little bit, which is you could say that the violation is complete upon the taking of the property with a denial of compensation, as Justice Alito just alluded to, as you've just denied that any compensation is due. Or you could say it should wait until a state litigation process is exhausted itself. And maybe it makes sense to wait when the state has acknowledged a duty to pay, and we can say the state's probably good for it. And that's where those cases originally came from, Cherokee and some of the early ones. But maybe it doesn't make sense when the state has denied any obligation to pay. Maybe it is different when it's an inverse condemnation, because when we look at other constitutional rights, we don't say that a First Amendment violation isn't complete until someone has litigated that claim in state court under state processes, or a Fourth Amendment claim. And when you look at the history of inverse condemnation suits, they originated in common law under trespass. It's a simple claim against the state for trespass. That's what an inverse condemnation suit is. Nothing more, nothing less. So why should we single out this particular right, the takings clause, for such disfavored treatment to await to exhaust state remedies that wind up, in this ripeness world, to yield a moot federal claim?
A couple of answers to that question, Your Honor. Number one, we are not giving disfavored treatment to property rights. The Constitution does not protect the right to hold on to your property when the government has a just reason to take it. And what the Constitution protects is the right to get just compensation for that. And this Court, since I think 1895, has specifically said inverse condemnation is an appropriate form of providing that reasonable, certain, and adequate compensation.
But we could say the exact same thing with